We've been following and monitoring this afternoon the closing arguments, which have just wrapped up in the case to remove Fani Willis, the DA in Fulton County, Georgia, in that case against Donald Trump. We'll have a decision we expect maybe within a couple of weeks. That seems to me like, I don't know, maybe a long time. At the same time, that case was wrapping up, resting today in Georgia. Donald Trump appearing in a Florida courtroom and the classified documents case, and the Supreme Court taking up a case on whether or not to delay all of the trials. At the same, and this is on top of this, don't even forget about Illinois taking Donald Trump off the ballot this week. And, of course, there are the fines and penalties that Donald Trump has to pay. It's hard to keep up with as someone covering these as news stories. I can't imagine being a part of his legal team. And to help us sort this out, Jeremy Rosenthal is joining me. He's a trial attorney, founder of TexasDefenseFirm.com. He's been a prosecutor, he's been a defense attorney, and he's joining me now on the Scott Sands Show. Jeremy, this seems like a mess for the former president, but so far, except for, millions of dollars in penalties, he seems to be winning the major political fights.
The political fights, yes, baby. I mean, legally, these things they're going to take a while to sort out, and that we're all getting a front row seat here of how the sausage is made in our criminal process, in our court process. So it's long, it's laborious. It doesn't lend itself necessarily to a political calendar, as we're finding out. But yeah, there's a lot to sort through here.
Let's start, if we can, with the Fani Willis case. Is it unusual for a DA, for an attorney, defense even, to hire someone that they're close personal friends with and pay them to be a part of the team? Is that unusual, or does that happen more often than you would think?
Well, I guess the legal practice, unfortunately, can be more incestuous than we would like. My hope is that this is pretty rare, and I do think it's pretty rare. And maybe she got caught doing kind of an inside handoff here. We'll see what the net result of that. What the court's ultimately going to do in that case is what's called a harm analysis, meaning that they're going to kind of take it back to the defendants in the case, Donald Trump, and say, okay, so we got some hanky panky going on here. That's not good. Does it impair your ability, Mr. Trump, to defend yourself? Or on the other hand, does it stink so bad that the DA's office here has lost so much credibility that we just can't have them prosecute the case anymore? That's going to be the central issue here. The ones that I talk to, the folks that I talk to, seem to think that the judge in that case is probably going to, if they take Miss Willis off the case, they'll probably keep it within the Fulton County DA's office, meaning that's a big office. I mean, there's a lot of lawyers that work there. Maybe another one picks it up. Maybe she gets disqualified. It gets farmed out to a completely different set of prosecutors who may look at the case completely differently. A lot of different ways that this may shake out in Georgia.
As I look at this case, I think there's obviously some hanky-panky, in your words, that's gone on there. And I think it's entirely possible that Fani Willis and Nathan Wade may face some sort of disciplinary action for unethical behavior. But that doesn't mean whatever facts that they uncovered don't matter in the case against Donald Trump. Now, you can then make the argument that Donald Trump shouldn't be prosecuted in this case to begin with. That's a whole separate argument. But I don't know that any unethical behavior affects the DA's office ability to prosecute Donald Trump in this particular case. And then Donald Trump would have to be determined guilty or innocent based on the actual facts and evidence.
I think that's right. Now, one thing that's kind of interesting about this is that Ms. Willis, I mean, when you're an elected official in a big office, you don't try a lot of cases. When you're a small town prosecutor, you might probably try a lot of cases. So it's not unusual that she would go and try to find another lawyer that would help her out. But you would think that there would be somebody already in the office that's used to handling similar cases to that, or at least as close as you can get. So it would be concerning if she was shopping it around, meaning that, I'm going to go to some of the local attorneys who are really good. They got a lot of street cred. And you don't want it. Okay, well, and you don't want this case. Oh, and you don't want this case. I know who'll take this case. My buddy will take this case, right? So that part's a little concerning. But you're correct. I mean, ultimately, This case is about whether or not Donald Trump gets a fair trial, and whether Miss Willis faces disciplinary action or not. You're absolutely correct. Is just it's completely independent of the facts of this case, of whether or not Donald Trump committed a crime for which he may stand trial. That's the central issue.
We're talking to Jeremy Rosenthal, founder of TexasDefenseFirm.com. The other big case this week is the Supreme Court taking up Donald Trump's claims of immunity. This is a much bigger, broader deal that has far-reaching implications. I mean, if the Supreme Court rules in Donald Trump's favor, this is lasting precedent for the commander-in-chief.
Scott, you're a good lawyer, man. I'll tell you what, you've hit the nail on the head here. I don't want to over dramatize this, but this may be the biggest separation of powers case that we see in our lifetimes. And I'm not going to say it's the biggest since, at least separation of power since Marbury versus Madison, but this is about what can the president do and not do and be prosecuted in office. If we take it to its literal extreme, right? Can the president just say, and the Supreme Court's not looking about this election, about Donald Trump versus Joe Biden, or at least I hope they're not. They're looking at 5 years, 10 years, 20 years, 50 years, 100 years down the line. And what they're asking themselves is, okay, can the president of the United States just say, you know what, I'm not going to pay taxes and you can't prosecute me because I'm the president? Can we do that? I think the answer is going to be no. But then we've got an impeachment currently going on because a secretary is alleged in the articles of indictment that you didn't defend our southern border as you were charged. So where's the line, right? If Joe Biden loses this election, can he turn around and be prosecuted in theory for not defending the southern border? And where's the line drawn, right? I mean, obviously somewhere between the president just can't decide not to pay his taxes, and somewhere between, well, hold on here, we don't prosecute somebody just because we didn't think they were quite up to the job.
Right. Just so you can't prosecute somebody for doing a bad job. And as you talk about the southern border, you can look at that two different ways. Is that treason? Is that allowing a foreign invasion of the country you were sworn to protect, or is it just a policy decision on the laws that you're going to enforce? And that's a way to look at the prosecution. Jeremy, the way that I look at this Supreme Court case is, what if this decision was reached in favor of presidential immunity in the 1960s before Richard Nixon? Watergate wouldn't have been an issue at that point.
No, you're correct. Now the court can only decide what's in front of it. But you're absolutely correct. And so knowing that they're going to decide what's in front of it, another really big factor here that I think that the Supreme Court's really thankful for, candidly, is because the sitting president is not the one that is under indictment. It's a former president. And that makes a big difference for the reason that a private citizen has the rights commensurate with a private citizen. If it were the executive getting prosecuted in office, then you've got the whole question of, well, hold on, we also have to run the country here, and we can't be, it's the same, it's kind of analogous to the can a sitting president be sued, right? And that was a big debate too, because we don't want the president to be harassed and upset. You know, we need the president to kind of do his thing. A very fact-dependent situation, obviously, as they all are. But again, this one is going to be pretty big, and I think that's why the Supreme Court decided to hear arguments. I think most experts thought that the Supreme Court would rule this week on the immunity claim and just not hear arguments at all. But we'll hear what they have to say about it, and it's going to be pretty interesting.
It's going to be very important, and I think that what makes it interesting right now, even though this is immunity claims for a former president, if Donald Trump wins in November, I mean, most of these cases could be punted down the road until he's in office. So then do you delay those trials until those 4 years are up, when then he's 80 some odd years old? Or do you try to prosecute the cases while he is in office again? Or does that re-election reopen the claims of immunity? I mean, this is a never-ending cycle with this guy.
This is all first impression stuff. None of it has happened in American history. So everything that we're seeing is indeed the first of its kind. You've got two state level prosecutions going on. And in theory, the president of the United States could be in a prison in Georgia when his office when he's supposed to be taking the inaugural oath on January 20th next year. I don't think that happens. I mean, we're in the realm where we're actually discussing it, right? So again, really fascinating stuff. It's kind of like watching the weather. You know, we can look at the weather, predict the weather, but ultimately the weather's the weather. These are all, you know, a lot of humans, a lot of variables, a lot of different things, ways that it can shake out. All of them fascinating, at least to us.
We're talking to Jeremy Rosenthal, founder of TexasDefenseFirm.com. And to get reelected, the president's going to need to be on the ballot. Now, right now, these ballot removals that have taken place around the country have all been for primaries. Illinois, the latest state to take Trump off the ballot because of the insurrection ban, which, I mean, at some point, somebody at a federal level, somebody on the Supreme Court is going to need to define what happened on January 6th, whether or not that was an insurrection. That's the only way these ballot removal claims can go away, is if somebody somewhere rules that it wasn't an insurrection. And we can't have individual states taking somebody off the ballot.
Right. So I think what you're going to see, I think most folks would tell you that Trump is going to lose the immunity claim, but he's going to win on these grounds. He's going to win and get back on these ballots, and he may get some favorable rulings on these ballot cases pretty quickly in the next week or so here. But you're exactly correct. I mean, these statutes, I mean, the 14th Amendment to the United States Constitution was enacted in the wake of the Civil War. It was made to make sure that we don't have somebody who is a Confederate general to come and lead the United States of America. And so it is a real limitation, if you will, on the state's powers, yet the states are taking the position, no, this allows us to do this. Where I think this is interesting, if you think about it like this, and I'm just going to kind of nerd out on you here for a minute. But if you really think about it, what's to stop Barack Obama from putting his name on the ballot? Or if Donald Trump wins and then wants to run for a third term, what would the mechanism be like there to remove somebody from the ballot? The Constitution says if you've been elected twice to be the president of the United States, you're not eligible to be elected again. So what's the mechanism by which a state can remove a candidate? That's what we're actually defining here.
That's fascinating, because
so, yeah.
the Constitution would say you couldn't serve as president, but it doesn't say anything about being on the ballot to be elected as president.
How would North Carolina? How would Arkansas? How would these states? If somebody who is Bill Clinton has served 2 terms as the United States president, he's been elected twice. If he decided in 2028, I'm going to run for president, he goes to pays his however many bucks in whatever state, and what do? I don't know. That's what our court system does. We answer these questions through these cases. So we're learning all these things again for the first time. And again, you kind of made the point originally that the allegation is that that there was an insurrection or a violation of the insurrection clause of the 14th Amendment. Well, who gets to define that, right? That's the issue that you've hit on, and I think that's where you're right. That's where the courts are going to come in and say, well, yes, no, maybe so. Now, what happens if he's convicted on the January 6th case? If he's convicted there before November 8th, I don't know if any state can try to say, okay, now you've been convicted of something. Does that change their position? Again, I don't know.
I should have stayed in law school. Jeremy Rosenthal, founder of TexasDefenseFirm.com. Great to have you on, man. Let's have another conversation soon.
Love to. Thank you.